maybe that this is one we need to put up later from the recording.
Okay, then we'll go on ahead and do that. Thank you very much. We'll go on ahead and get started, knowing that today's argument is being recorded and will be live stream or will be later posted to YouTube for all of your viewing pleasures. Good morning again. Welcome to this morning's oral arguments before the Kansas Court of Appeals. We're meeting today remotely because of the latest in a series of winter weather events that has racked our state over the past couple of months. So thank you, counsel, for being willing to pivot and appear remotely today. My name is Judge Sarah Warner. I'm joined today by Judge Catherine Gardner from Topeka and Judge J.C. Hurst from Lawrence. I'll be presiding over today's docket, which primarily just means that I'll be keeping track of your time as you're arguing. We're going to be hearing one case this morning, and in preparation for today's argument, we have thoroughly reviewed the parties' briefs and the court record, along with a legal memorandum that's been prepared by a research attorney. So we are very familiar with the facts, and we encourage the parties to just dive right into your legal arguments. Each side today has been scheduled for 15 minutes of argument, and we also have a cross appeal. And that means that both sides will have the opportunity for rebuttal if they so choose. And so as you state your appearances, just go on ahead and let me know if you'd like to reserve any of that 15-minute time for rebuttal. With that, we turn to the case before us. It's case number 126435 out of Riley County, the Board of County Commissioners of Riley County, Kansas versus the Kansas Historical Society et al. Would the parties please state their appearances?
Yes, Your Honors. Bryant Parker, attorney for appellant, Riley County Commissioners, and I would request 5 minutes be reserved for rebuttal. Thank you.
5 minutes are granted. And Mr. Parker, you did enter your appearance. You weren't on the briefs, but you entered your appearance. Is that correct?
Yes, Your Honor.
All right, thank you. Counsel?
Your Honor, this is Whitney Casement appearing on behalf of the appellees and cross appellants, the Kansas Historical Society, the State Historic Preservation Officer, and the Kansas Historic Sites Board of Review. And I do not need any time for rebuttal. Thank you.
All right, thank you. All right, with that, Mr. Parker, you may begin.
Thank you, Your Honors. May it please the court. And I will say up front that I have timed my argument, and I believe it's about 4 minutes, 4.5 minutes. So there should be plenty of time for questions throughout whenever. As new counsel coming up to speed on this case, I actually originally agreed with the trial court's entirely. And if I was in the court's shoes, I would have voted to uphold it as an appellate judge. But after considerable thought, I now have second thoughts, not just because I represent my client. The state's argument is, in essence, that because the KHSB had statutory authority to list something on the state registry and approve applications for the National Federal Register, it doesn't really matter how they got there. After all, a hearing was held. We disagree. And for the reasons I'm about to explain, my client was denied due process in a meaningful hearing because the state had not adopted regulations to consider listing on the state registry. They had no lawful process for listing on the state registry, and that's important. So we couldn't refute the listing on the state registry even if we wanted to. We didn't know what the rules were. There were no rules for the hearing, other than that they had a hearing. Yes, KHSB could approve an application for the National Registry under plain statutory language. We don't dispute that. But KHSB didn't even have regulations defining what that means. Does it require them to make findings of fact? We don't know. The statute doesn't say that. In their hearing, KHSB made no specific findings of fact other than to approve the application. Yet the federal facts were talked about, but they didn't make on the record. I went back and looked. Yet the federal application was sent by the SHPO certifying that the property was already listed in the Kansas Register. This means that, as communicated by the SHPO in the National Register application to the National Register, KHSB had fully endorsed the statements in the National Register application as true because, like all state level registries, they track what the feds have in their registry regulations as well. Now, we also allege this.
Counsel, but before you go on to your other allegation, I want to ask you a question about that.
Sure.
So the statute, I would agree, is fairly bare bones, right? But the statute does say that if that the state registry shall include anything that is on the national registry. So once something has been, once the Park Service has certified something and placed it on the national registry, would you agree that it's lawful to place that on the state registry?
Oh, absolutely.
And the national registry that looks at the State Historical Society to make that nomination, and that nomination was made.
Oh, absolutely.
And so, and I just, is it the county and the board's position that it was only unlawful from August until March of August 2021 until March of 2022 in terms of the registry placement on the state registry, or is it kind of ab initio and forever?
Well, and that's the crux of the argument, right? And I would argue, and that's why after reviewing the briefing, I wanted to clear up what distill down what I believe the county is really arguing, right? The property is lawfully listed on both the national and the state registry at this point. I don't dispute that. County doesn't dispute that. The problem is that the justification for getting it onto the national registry, and this is where my client was harmed, right, is there was no hearing held at the national level to dispute these findings, right? We already had a state level board make a certification to the federal government that it met that this property, by listing it when they listed it on the state historical registry, right, that whatever was contained in that application that was forwarded on by the state SHPO as authorized by the Kansas Historic Site Board, right, all of those facts are true. Because after all, that independent body listed it in the state, right? Listed it on the state registry. Therefore, if I'm a Fed, of course, all these facts are true, and I'm just going to sign off.
Counsel, so I just want to be clear. There was a hearing as to whether it should be listed and nominated for the National Registry, and the Historical Society made those findings that it should be nominated for the National Registry. That's what the hearing was primarily focused on, right?
We would strongly disagree. It was how can you have a hearing if you have no rules?
But counsel, there are rules at the national level. There are rules at the national level, and those are the rules that the state body was enforcing. So I guess I just don't really understand where you're drawing the line here. I can understand your perhaps your argument with regard to the state registry, but it was my understanding from the briefs that there's no question that, and you're not contesting the placement on the national registry.
That's correct, Your Honor. And the reason for it is that let me put it in terms that I think help clear up where we're coming from. Would it be proper for, let's say, on literally any other context in front of a judicial body, right? Can a judicial body lawfully act if it's governed by no rules?
So it's your contention that the application then is void. The application to the National Registry then is void for lack of procedural rules by the state board?
Your Honor, it's not that the application is void. It's that the application avers facts and then gives the color of state authority that they have made findings that support everything in that application to be true because they listed it on the state registry. And not only did they not have rules that implemented the statute to do that, right? They didn't have rules that specified, okay, how do we go about and make findings of fact? How do we have a proper hearing?
When I
Right.
read the statute, is it your contention then that the board is required to actually promulgate rules and regulations that are filed and housed somewhere in order to forward these applications to the National Registry?
It is our contention, right? Yes. And the reason why it's only because, right? And let me make that caveat. Only if they're going to list in the application like they did, that they certified that it was registered on the state registry, right? Now, if they just wanted to approve the application, right? They could do that. We could approve it, but you
So
can't
they don't
certify.
They don't need the promulgated rules. I apologize for saying that. We're weird.
I'm sorry, Your Honor, I couldn't hear you.
They don't need to promulgate rules in order to forward the application, but they
That's right.
do need to have those rules in order to say that it's registered on the state. Okay, so let me ask you this real quick. It automatically becomes registered with the state once it's registered nationally. So your contention is if they had forwarded the application sans marking that it was registered with the state, and then it became registered nationally, it could be registered with the state and we would have no problem.
Absolutely. And I'll explain why, Your Honor, right? If they just forward the application, they approve it, right? What are they really doing? Yeah, these are all the things that are listed. We're alleging this to be true. You guys decide. That's not what they're saying. They're saying we have made a finding
Well, it
after
sounds to me like you are, counsel, it sounds to me like you are challenging placement on the National Registry after you have specifically indicated in your brief that you are not.
No, Your Honor. This would not be, right? This would not be. We have no right of redress before this panel to get it delisted from the Federal Registry. What we are challenging is that a state board can make a certification that the trial court said itself was unlawful, and then send an application to a federal entity that, of course, is going to defer to a state board's findings that it is eligible to be on the state registry. That's what we're saying. If you go back and you read the transcript of the hearing, Your Honor, right, it's completely unorganized, right? There was correspondence before the hearing from my client saying, what are the rules, right? What are you guys trying to, what are the rules of the hearing, right? And they said, well, generally we follow the rules of the Federal Registry. Okay, then that's great. Are you inviting your board to make findings of fact? There was no invitation to the board to make findings of fact. They were handed an application and then they approved it. How does that, right? That is why the statute, KSA 75 2721A2, prepare and maintain a state register of historic places, right? Which shall include all those listed on the National Register of Historic Places. The Historical Society shall adopt standards for the listing and maintenance of historic properties. Why did the state legislature think it was important to say, hey, you got to adopt some standards, right? Because they knew.
Counsel, could you give us an example of what standards would have made a difference here?
Oh, absolutely, right? There are 4 standards under the federal law, right? Then the Federal Registry has all kinds of interpreting regulations, right? That would have said, right, okay, if you're going in front of this as a hearing at the federal level, this is what we think this means. This is what we think this means. This is what we think this means, right? We have no idea how the State Historic Preservation Board, or excuse me, State Historic Site Board is going to independently interpret and apply the federal standards, right? They just say, well, we're going to look for these things. Number one. Number two, how do they prefer to receive evidence, right? Do they want to have testimony? Do they want to have written findings prepared? What is the standard in the record itself, right? There was talk about, do we need an engineering study? Do we need to have some kind of a state historic? Do we need to have an expert in historic boards, or excuse me, in historic buildings come in and provide testimony? My client had no idea what the board was looking for. We were just told to show up, right? And that they were going to consider it. How can we?
Council, we are now at 13 minutes, and so I want to make
I'm
sure
sorry.
that if you want to reserve your full 5 minutes for rebuttal, we've had some questions, and so I'm going to allow you 5 minutes. But if you want to continue arguing now, then you will start eating into that rebuttal time.
Well, all I'm going to say is that the remedy that we're seeking, Judge, Your Honors, is, and I'm aware that 2 members of the panel have degrees in French. So I would never presume to pronounce any foreign language because my French is terrible, let alone my Latin. But where there's a wrong, there's a remedy, right? And the wrong here is not that the federal government followed their process when a state has already listed a property on the state register, right? They're basically a rubber stamp. I'm sorry, that's how this works in the real world. I've practiced in this area of law. Feds are a rubber stamp. If the state's got it listed, they're going to list it too, right? When we got a trial court saying that they didn't have the authority to list it, right? It was an unlawful act, and then the feds rely on that, right? We believe that the state historic board should be instructed to remove it from the state registry and then request and explain to the feds that they should remove it too, because the feds relied on their certification that it was on the state registry in their fact finding. That's what we're asking for. And I'm fine with just 4 minutes for rebuttal. Thank you.
Thank you, counsel. Thank you. Ms.
May it
Casey?
please the court? Thank you, Your Honors. This court should affirm the decision of the district court, which upheld the Kansas Historical Society's actions with regard to the First Christian Church property for the following reasons. First, the district court correctly held that Riley County's claim regarding the legality of the August 2021 listing on the state register became moot once it was listed on the national register. Second, the county absolutely had notice of the property's nomination to the state register and sat on its rights, thereby failing to preserve its objections for appeal. There are no due process concerns here. Third, the Kansas Historic Sites Board of Review acted within its statutory authority when it considered the nomination of the First Christian Church property to the state and national registers. Now, appellees have also requested that this court reverse the district court's holding that the Kansas Historical Society prematurely listed the property on the state register when it was approved by the board in August 2021, before it was approved by the national register. The arguments by my opposing counsel were a little different, I think, than what was in the brief. So if you have any questions, I'm happy to answer them. But otherwise, I'm going to sort of stay on my agenda that I had planned for this.
I do have one question. Were the arguments today, or that are the arguments in the brief, different than the arguments they raised at the administrative hearing?
The arguments that were raised at the administrative hearing were essentially twofold. First, the argument was that the property did not meet the criterion for listing on the national or state registers. That was their first argument. They have abandoned that argument on appeal. They're not questioning whether or not this property actually qualifies under the National Register criterion. The other argument that they made at the state administrative hearing was that Essentially, the state standards for listing on the state registry were vague and needed to be essentially, there need to be more clarity in the regulations in order to determine what exactly was being required of them. Now, in their brief, they didn't talk about that either. That also, they have essentially switched arguments to argue that there was a premature listing and that it shouldn't have been nominated for the state register at all, or that it shouldn't be considered because it wasn't nominated. They have switched their arguments at this point. And so they didn't really preserve this argument. They did not preserve this argument that they're making for appeal. The question, what's being argued today, again, is a little different from what was actually in their briefs. Because what was in their briefs on appeal is specifically was that, hey, it was never nominated for the state register, so it couldn't be considered for the state register. So they are different, Your Honor. The answer to your question is yes, they are different.
Counsel, could you talk to me a little bit about the process for placing a property on the National Register? So the National Register defers to these state boards to make a nomination. Is that right?
Well, it doesn't defer, Your Honor. So what happens is it's considered by the state board. The state board makes a recommendation about whether or not the property meets the criterion, the national criterion, and then they forward their recommendation to the National Park Service. But the National Park Service is ultimately the authority that decides whether it actually meets the criterion. Now,
once that recommendation has been made to the Park Service, what steps does if any, and if you're aware, does the Park Service take to then approve that recommendation and place something on the National Registry?
What I do know is that a property owner can make an objection to the National Park Service, and then the National Park Service has to go through a process of giving them a chance to be heard. The property owner.
Are you aware, and this is I think beyond our record here, but are you aware as to whether that the county submitted an objection to the National Park Service?
I am not aware of any objection that was submitted to the National Park Service.
And there's certainly nothing in the record before us that includes that. Is that right?
Correct. Correct.
So is that what you were alluding to when you said the county sat on their hands, or is that something different?
No, that's not what I was referring to. What I was referring to is the county knew that there was a nomination to the state register. They were sent a letter in June 2021, before the August 2021 meeting of the board. And that letter is at volume 2, page 212. It specifically says, this is being considered for the state register. And then you also have a transcript.
And does it identify the process by which they should object to the consideration?
I'm sorry, I can't quite hear you.
Does it identify the process by which they could or should object? Like a formal.
Does the letter identify the process?
Right.
I would have to actually pull that letter up to see if it does. But Your Honor, to answer your question though, the board as a state entity is governed by the KJRA. And so they have to abide by the KJRA in their meeting and give the parties a chance to be heard. I don't think there is set forth in that letter specific ways to object, but I will say there were objections made in a letter before that hearing, before the state agency meeting. The Riley County did have a letter it sent with objections, and those objections were the twofold objections that I mentioned earlier. Hey, it's not clear what the criteria are for the state registry. And there was nothing in that letter about, hey, we don't think this has been nominated for the state registry. There was no objection. So when I say they were sitting on their hands, that's what I'm saying. They knew in June of 2021 it was being nominated for the state register. They sent a letter objecting. They obviously knew they could object, and they didn't include that objection in there.
Council, that letter though, the objection letter that was submitted in early August did say, as you have stated, that we don't know what the criteria are that are going to be considered in order to determine whether something is placed on the state register. What are those criteria?
So the criteria are essentially it's just the national criteria. This property was nominated using the national criteria. And we know that it meets the national criteria now because it's been listed on the National Register. But the national criteria are what is used for determining whether the property should be listed also on the state register. It's the same.
So when KSA 75 2721 says that the Historic Society can adopt and promulgate rules and regulations that kind of to affect this process, what there are no rules or regulations that they have promulgated. Is that right?
No, that is wrong. They do. I don't have the record site in front of me right now, but there is a regulation that states essentially that the national criteria will be applied for consideration of properties for the state register, but just in a more flexible manner. We do not necessarily talk about that in our brief, because they really abandoned that argument on appeal. They're not talking about the criteria on appeal. And also B, because only the national criteria were used. There are more stringent criteria. And so the board only applied the national criteria and made its finding that the national criteria applied, and that the property not only qualified for listing on the state register, but the national register, without consideration of the more flexible standard.
And so I want to make sure that I understand that the Historic Society and the board had maybe the flexibility to, and have indicated that they have the flexibility to consider kind of other standards or lesser standards, but it doesn't matter because those weren't applied here. That's your position?
That's correct.
Okay, thank you.
That is correct. And beyond that, my other position is when we're talking about criteria, I guess I want to be totally clear. The criteria speak to things like, does the building have the integrity, the historic integrity it had at the time? Or has it been changed so much that it's really doesn't have the integrity of the times, right? So it's more substantive. That was their argument at the hearing and the meeting of the board. And they're not making that argument now, that it doesn't meet those substantive criteria. Now their argument is, well, it was never nominated for the state register, and we didn't have notice of that. So they've switched arguments, and so the question of whether or not the state criteria are too vague, that's really not before the court. I also want to talk about sort of what this case is also not about beyond the criteria. So the county abandoned their argument about the criteria long ago. The county is also not arguing inconsistency or lack of uniformity in the board's longstanding practice of considering a property to be nominated for the state register when the national register form is used. Okay, so they're challenging the board's decision under KSA 77-621C4, arguing that the board erroneously interpreted or applied the law. There is a different provision of the KJRA that does, where they could have argued that the law was applied in an arbitrary manner, wasn't applied uniformly. They're not arguing that here. They have not cited that provision. So I'd like to address the mootness argument. When the National Park Service listed the property on the National Register of Historic Places, as we know now, Kansas statute provides that it automatically goes on the state register. And I just want to be clear, whether or not it's placed on the state register has no impact on whether it will be placed on the National Register. You could have a property nominated for the National Register only, and the board approves it, sends the recommendation to the National Park Service. National Park Service says, great, we're going to list it, regardless of whether or not it is placed on the state register. Those are entirely separate questions. So to say that placing it on the state register had some impact on the National Park Service's decision to place it on the National Register, there's no evidence in the record for that. So as I said, it was approved when it was approved for the National Register in March 2022. The question of the legality of the August 2021 listing on the state register became moot. An issue is moot, as we all know, when there's really no controversy before the court. The only judgment that could be entered would be ineffectual for any purpose, and it would not impact any of the parties' rights. So here, there's really no discretion left for the board. They really can't make a recommendation for removal of the property. Once they've decided that the criterion were met, their job is to simply say, criterion are met, we recommend that it be listed on the National Register and pass that recommendation along. That is what they're bound by statute and regulation to do. So any relief that could be provided by the courts, that's provided by the courts, would be ineffectual. It would not impact the parties in any way. And that's what makes their argument moot. Now, they are arguing an exception to mootness, and it's our position that exception does not apply. The exception they're arguing is that Riley County, that this is an issue that is likely to evade review. And that's simply not the case. Because they had notice that it was being considered for the state register, they had a chance to object. This was completely avoidable. They sat on their rights and they didn't object. Had they done so, they would have given the board the ability to correct a mistake if there was one. And they didn't do that.
If we, let's say that we disagree and we think that that mootness exception could potentially apply, does that change the outcome?
No, no, excuse me, it does not. That's just one of many arguments. If it's moot, obviously, you would be able to affirm the district court decision. But there are other arguments we have. For example, they failed to preserve their arguments for appeal. And so the court could actually affirm the district court's decision on that issue alone. The fact that they did not preserve these objections at the time of the administrative hearing. In addition, we have our other arguments that the listing on the state register was legal. It was within the authority of the board to do and for the Kansas Historical Society to do. It was not an erroneous interpretation or application of law. And their longstanding practice of considering properties nominated using the national form as being also nominated for the state register was legal and is not required to be published as a regulation. So to answer your question, even if you do not find for us on the mootness argument, there are other arguments you could consider and still determine that the property was legally listed on the state register as of August 2021.
Thank you, counsel. We've asked you a lot of questions, but if you want to take 30 seconds to wrap up, go on ahead.
Absolutely. I will just say, I'd ask the court, and I'm sure you have done this, to look at the Hallmark versus Kansas Department of Commerce decision. It speaks to when a regulation has to be adopted. And this, because this is a ministerial act here that we're talking about, requires no subjectivity or discretion. This practice of the board is not required to be a regulation. And for these reasons, Your Honors, thank you for your time today. I'd ask that you affirm the decision of the district court, and also that you would reverse the district court's decision finding that the August 2021 listing of the property was premature. Thank you.
Thank you, counsel. Mr. Parker, you have 4 minutes for rebuttal. And I was wondering if you could start by addressing the mootness question. Oh, you're muted, sir.
That's somewhat ironic that I was muted when I was addressing mootness.
Right.
Yeah.
We have to find humor where we can, right? Go
Yes,
ahead.
Your Honors. So mootness, going back to learned counsel's argument, I would agree that unless the state takes the action that we're requesting them to take, which is what the relief that we request on the trial court to instruct, right, the state to delist it and then make an application and then have the state, which they have the statutory authority to do, request the feds to delist it, then yeah, it's moot, right? Reason why it's not moot is that the whole reason it got listed on the federal registry is because the state forwarded the application subject to the certification, right? Now,
is certification something that that is a factor that the National Park Service considers?
Your Honors, I think it. While I don't have the federal regulations in front of me, I think it would be difficult for a federal finder of fact to not infer, right, that there's some validity to the averments in an application if an independent state body that is supposed to have thoroughly reviewed this application doesn't just approve it for being sent on, but lists it on their state, right? Believe that carries quite a bit more weight than just saying, yeah, this is an application that we had, right? Please consider it. Now, I wanted to point out two things, how circular the state's argument is, right? Right? We didn't go down through rules. We didn't have to adopt rules, right, to do what we did. And I'm going to, wrap up with two thoughts very quickly. But now that it got listed onto the feds, what difference does it make? I think you got to have some rules if you're an administrative body, right, that are more than just what the Kansas APA prescribes. I want to hone in on the last 30 seconds, the conclusion that learned counsel made, that this was a ministerial act, right, that did not require the adoption of regulations. That in and of itself, that statement should justify the relief that we are requesting. And that's why, in terms of these issues being preserved on appeal, right, we weren't appealing that the district court judges finding that what they did was unlawful and illegal. They'd already held that the heart and soul of our argument, right, that what they did was illegal and shouldn't have ever been done because it was arbitrary and capricious and it went beyond their power because they never made rules, right? They had already found for that. So we were just expounding on the district court's finding, right? And we said that in our appellate briefing. We said we wholeheartedly agree, right? So I don't see how we could have done a better job of preserving something that had already been found below that we agreed with. We weren't appealing that. We were just saying that there had to be something that they could do, and we identified what it is. They could ask it for it to be, right? Now, to argue that somehow making a finding of fact by an administrative tribunal in adjudicating in what's a quasi-judicial interpretation under Kansas law is a ministerial act, that contravenes literally all of the case law on ministerial acts versus discretionary, right, in the state of Kansas. Now, I too think that Hallmark Cards is an important case because it says that it could be inherently arbitrary and capricious for a body to fail to adopt regulations to implement state statutory authority. And that's exactly what we are alleging happened here. And finally, a couple of things to hopefully wrap up. Things that should have been dealt with at the state level. How to present evidence. How the state board interprets more liberally the national registry. To take regulations that you say apply and they say, yeah, but we're going to go more liberal than that. Well, that's the definite, that is creating a gap. It's creating a gulf in what you're trying to apply. Now, did we preserve this at the hearing level? Oh, absolutely. It's the subject of, and very quickly, I would refer to my predecessor's entry of appearance, a letter dated August 6, 2021, where we identify all of these issues and that we're shooting in the blind. And most importantly, right, going back to the letters that this panel asked about, whether there was any procedure identified when we were notified, right, by letter that it was going to be considered? Absolutely not. In fact, the procedures discussed in the June 26, 2021 letter, which is before the tribune, before this panel, as part of the record on appeal, I would say AG 000536 and 537, they talk about how owners of private properties that are nominated, right, have an ability to object. They don't even say how an owner of a public property.
Counsel, I've allowed you to run a couple of minutes past your rebuttal time, but I'd like to give you 30 seconds to wrap up.
Thank you, Your Honor. That's basically, and then as we go through, I'll only take 15 seconds of it. When we go back to the other letter in the record, which is all in that AG 000536 range, right? When they say, congratulations, you've been listed, they don't even explain what the next steps are, right? And they say we've been listed in the state. They don't say how they're sending it off to the feds. They don't say when they're sending it off to the feds. They don't explain to us how, right, we might get in touch with the feds. We're just left to guess. So I think everything that we had to say has been argued. Thank you so much.
Thank you very much. Thank you to both counsel for your written arguments and your arguments today. We'll take the matter under advisement and issue a written opinion sometime as soon as we're able. Thank you very much. That concludes today's arguments, and court is adjourned.
Thank you.